Good morning. May it please the court, counsel. My name is Matthew Funderburk, and I represent the petitioner Laverne Brown. We're here to discuss the 5th District Court of Appeals opinion regarding the 22-point statute, specifically the second sentence of that statute. The 5th DCA held that Apprendi and Blakely did not apply, and that was primarily because they found it to be a mitigation statute. This decision was incorrect for a number of reasons. First, the statute is not one that mitigates an offender's sentence. As the dissent stated, the majority simply rewrote the statute, turned it on its head. The statute does not place the burden on the defendant to prove they are or that they lack a future danger. Instead, it creates a process for enhancing the sentence, a mandatory non-state prison sanction, and it does that exclusively on a judge-made finding without any jury involvement. This court has also categorized the statute as one of an enhancement type nature, and that was from Bryant v. State out of 2014. I think that the Fifth's holding makes sense if you find that it's a mitigation statute, but if you don't, I think that
Let me ask you a question about the process as to how this works.
Sure.
So let's say this person gets convicted and there's a sentencing hearing at a later date. Is that when, does the prosecutor make the request to the judge to exceed the guidelines? Is that how it starts, or does the judge do it on his or her own based on what they've heard?
I think it is a request by the state, and
Okay,
then
so-
the judge.
So once that request is made, just walk me through this at that hearing. What does the judge do? How does the judge get the information he needs or she needs to make these findings?
Well, that's part of the problem is that, at least in this case, the jury verdict was really the only thing before the trial court. I mean, there was a trial, but it was very limited. It was a petty theft.
Well, does the state proffer any testimony, any evidence to assist the judge in coming to the conclusion that this person is going to present a danger to the community?
Well, there's not really any guidance in the statute, unfortunately.
Well, how does it work practically if you're in the courtroom? How does that work?
Practically, it seems like they would request it, and the judge would find whatever he has available to him to use. In this case, in Ms. Brown's case, it was that she had complained of chest pains and used her father's illness as a justification to get out of crimes. But
So somewhere along the line, the judge heard a history from this person that she would feign these type of injuries or
Correct in
illnesses.
that.
Somewhere along the line, the judge heard that. Where does he hear that? Is it courthouse gossip or other judges, or does the prosecutor present that?
That's probably presented by the prosecutor in making argument that they think this person should be sentenced to prison versus.
Was there a what do they call it, PSI here?
I'm not sure about that, if there was or not in this case.
Because ordinarily that sort of thing would be in a PSI, right?
Right, correct.
Let me ask you this. So if the jury would have to make this finding,
Correct.
then you would have to have then a question on the verdict form that would ask the jury if this person is a danger to society.
Correct. Yes, and that would cure, obviously, the Sixth Amendment problem here, because then the jury would be making the determination either in a special verdict or in a bifurcated hearing where it's just to determine danger to the public.
Do they have those kind of, is
Yes.
that a normal process? Would you have such a bifurcated determination in the trial court?
Yeah, I think you could do it, be very similar to like a firearm, bifurcating the firearm, possession of a firearm by a convicted felon. You have one portion of the trial to begin with, and then you do the second portion just as to the firearm, so it doesn't taint the first trial. And this would be the same thing. You wouldn't want to commingle that information in the first trial, but you could separate it out and have a danger
In
specific.
this case, because it was a recidivism statute, there would have been a bifurcated proceeding to prove the prior misdemeanors for petty theft, except that the defendant stipulated to it, correct?
Correct,
So there would have
correct.
been a bifurcated proceeding anyway?
Correct. She did not dispute that.
Assuming that we agree with you, I'm just interested in whether you see a problem with the kind of dangerousness finding that the trial judge made here when you have a recidivist statute and the only basis for recidivism is prior thefts that she may steal again because which is all reflected in the score sheet resulting in a score of 22 or less and in the offense itself. Would that even be a proper consideration in a dangerousness determination in your view?
I do not believe so. I think you were correct in saying that that is already used in the calculation of getting to 22 points. We're already saying this person is such a low-scoring offender, but then it's used duplicatively to increase the sentence to prison. So it seems like you're going around what the legislature has tried to do here, which is tried to keep these people out of incarcerative sentences and keep them on.
And the legislature's presumed to know that every one of these petty theft is a, what is it, .2?
I believe it's 0.2 on a prior record, yes.
Prior record?
Very, very small.
Well, under your understanding, what would count as evidence to support a determination of this, that the individual could present a danger to the public?
Well, I
If
think...
it's not those things in the record that are reflected.
Right. Yeah, I think that it's very difficult in the cases of petty theft to find somebody to be a danger. I think the average person...
I'm not asking you what couldn't be considered, I'm asking what would count, because if I'm understanding what you're saying, nothing reflected in the score sheet
Correct.
is properly considered.
Right.
So if it's not that, what would be? Because we know the legislature's contemplating something.
Right. I think...
could count for that determination. So what would it be?
I think what they're talking about is people that get under 22 points, yet they're involved in physical altercation, physical harm to other people. Battery is one of the convictions where sort of what we practically deal with in these cases is battery, driving while license suspended, and petty thefts. Those are sort of the three primary ones that we see. And I can understand, battery can be just a slight touching or it could be more. And I would think that the legislature's probably contemplating people that are committing battery against the same person but still, score very low. It's possibly, something like that where you may have testimony from the victim come in, have the trial court have some testimony to make that finding.
Now, in this case, your client served her time in prison.
Yes.
The issue, therefore, about the remedy is likely moot, but what is your view about what the remedy should be? Should it be just an automatic reduction to a non-state sentence, or should it be consistent with some of our other precedent, and certainly Hearst,
Right.
that there is it goes back for a sentencing if the state chooses to do that before a jury?
I think the best example of...
I mean, because in the first district case, they talk about
Right.
just going back to a prior statute,
Right.
which would actually subject the person to a greater sentence.
Correct.
Which doesn't make any sense to me.
Correct. I would ask this court to follow Roderick Williams, the same remedy that was announced in that case. I know there was some contention about what the proper remedy was there, but I think this court got it right, and I think that the pending cases should be resentenced under the first section, which involves, no finding of a danger to the public.
Or at the very most, it would be a new
Correct.
sentence, resentencing, not by a jury. You're
Correct.
making a finding.
Right, correct. And I know harmless error does enter into this discussion, but I don't really think it's very easy to find harmless on these cases. I think there's such little facts on the record that you really yes, Apprendi-Blakely errors are subject to harmlessness, but
Sounds like she had some significant mental issues.
yeah, there was some other stuff going on, and a jury could, to say that no rational jury would ever find that she was not a danger to the public, I think is far-fetched. And I think that's the same in a lot of these cases, is that you just don't have enough on the
Well,
record.
wherever she went, I sure hope she got treatment for her underlying issues, which I doubt, unfortunately.
And in conclusion, this court should reverse the 5th District Court of Appeal on this and resentence under the first section of the statute. And obviously, moving forward on these cases, the finding, needs to be made by a jury. And I'll use the rest of my time on rebuttal if I need it. Thank you.
Good morning, Your Honors, and may it please the Court, my name is Marjorie Vincent Schrupp, and I am appearing on behalf of the state of Florida. As counsel noted, the underlying issue in this case is the constitutionality of subsection 10, specifically the second sentence in that statute. And I think the key issue in resolving that determination is what the relevant statutory maximum is in this case.
Let me focus you on Blakely versus Washington. Now, in that case, Mr. Washington pled to kidnapping his wife, correct?
Correct.
And under Washington law, that was a Class B felony, correct?
Correct.
And the Supreme Court explained in there that a Class B felony under Washington law shall be punished, they're quoting the statute, by confinement up to 10 years in prison. So that was the maximum penalty, correct?
Correct, based on the facts that he
And
pled to.
then they say, I'm quoting from the Blakely opinion, other provisions of state law, however, further limit the range of sentence a judge may impose. Now, wouldn't that describe the circumstance here? There is a maximum penalty of 5 years because it's a third-degree felony under Florida law, but there's another provision of state law that further limits the range of sentence that a judge may impose.
Your Honor, I think there's a key difference between what happened in
But
Blakely.
I mean, that is the case. There is a statute that does further limit what a judge may impose.
Yes, there is. There's a difference, though. In Blakely, the defendant's plea triggered that sentencing range. In this case, that didn't happen with the jury's verdict. The jury's verdict triggered the maximum penalty of up to 5 years in prison. The jury's verdict didn't automatically trigger a non-state prison sanction. That sanction does not come into play until the court...
Well, with her prior record, it triggered a provision of Florida law that says that you can't send someone to state prison without a finding, right?
Justice Lawson, I would respectfully disagree. I think the proper analysis in looking at the statute is to start with the jury's verdict. This defendant was convicted of a third-degree felony. And a third-degree felony, as we all know, is subject to up to 5 years in prison. So when the jury found this defendant guilty, off the bat, 5 years was what she was eligible for. We don't get to step two.
I hear what you're saying, but it just seems to fly in the face of what this text that we're looking at says. Because is that the language there says, under these circumstances, which are defined in some detail there, if these conditions are met, the court must sentence the offender to a non-state prison sanction. That seems to be what the law of Florida says, but then there's an out.
Correct.
That we're talking about here, the second sentence. And this written findings with respect to dangerousness that justifies aggravation of that sentence because what's in the first sentence flows inevitably from the jury's determination. Okay, based on the jury's determination here, what's going to happen is what it says in the first sentence. That's what's going to happen. There's going to be a non-state prison sanction. And to not have a non-state prison sanction, something else has to happen. There has to be what the statute here refers to as written findings by the trial court. So I'm having trouble understanding how that's not something that's going above. How that's not a finding that goes above what was authorized by the verdict of the jury.
Well, I think if you look at it this way, Your Honor, which is the state's position, is that you have to start with, based on the verdict, the statutory maximum that this defendant was eligible for, which was 5 years. We can't get
But
to
that's
point
not
B.
what the statute says that Justice Kennedy was just talking to you about.
Yes, and I
Is
understand
it?
that, Your Honor, but I think the starting point, you have to start from point A before you even get to point B, which is
Wasn't that
subsection
true
10.
in Blakely? Point A was there was a 10-year statutory max in Blakely.
Well, in Blakely, there was a significant difference from this case and the determination that was made in this particular case. In Blakely, the finding that aggravated in that case, and it essentially reclassified the offense that that defendant was convicted of, was specifically related to how the offense was committed. The judge made specific findings which recharacterized the offense that that defendant was convicted of. That isn't what happened here.
So the statute in Washington said that if someone commits this offense, this is the range of sentencing unless the trial judge finds exceptional circumstances. And then there were some examples in the statute of what constituted exceptional circumstances, right?
And the circumstances that the judge found in that case specifically related to the commission of the offense. And I'd like to point out a language in Apprendi that I think illustrates the difference. In Apprendi, the Supreme Court looked at the requirements of why we have a jury trial and why we have specific jurors, the jury make specific findings. But on page 484 of the opinion, they noted that, quote, if a defendant faces punishment beyond that provided by statute, when an offense is committed under certain circumstances but not others, it is obvious that both the loss of liberty and the stigma attaching to the offense are heightened. And I think that was key to Apprendi, that was key to Blakely, and all the subsequent decisions.
Let me ask you this. It just seems to me, I thought your argument really was that once the person was convicted, they were subject to the 5-year statute for a third-degree felony. She was convicted of the third-degree felony. But that you had to take another step.
Correct.
After that conviction to get to the point of where 775 would come in, because you have to figure out the points.
Correct.
And so just by that conviction, you don't have 22 points or less. Am I missing something in your argument?
No.
So what is the next step? That's what I want to know.
So we have a defendant who's convicted, as in this case, of a third-degree felony. We start off with eligibility for up to 5 years. The next step, based on what the statute says, is we look at the offense to make sure it's a qualifying offense, not a forcible felony or a conviction under Chapter 810. And then we look at the total sentence points. And Judge Osterhaus, in the first DCA opinion in Woods, in his concurrence, made a good point. He said, if we look at the score sheet and the factors considered in that score sheet to establish the statutory maximum, then we're actually doing opposite of what Apprendi states.
But
So
isn't that argument completely inconsistent, it seems, with Booker? Because in Booker, the U.S. Supreme Court was looking at the federal guidelines, which was a point system that considered all these other things, and they said it can't set it was a minimum sentence there. You can't set a minimum sentence based on these sentencing factors that are not determined by the jury. Isn't that? And that seems to be, your argument seems inconsistent to me.
if you look at the statute, and there are different ways to look at the statute, because obviously even the dissenting opinions and the concurring opinions in Woods have looked at the statutes differently. If you look at subsection 10 totally in a vacuum, obviously yes. If you're going from a non-state prison sanction to a 3-year, 4-year, or 5-year prison term, obviously that would be an increase from that particular starting point. But you can't look at the statute in a vacuum. You have to look at it as a whole. And in that case, it really is more of a mitigation statute, which gives the trial judge, under a specific circumstance, the discretion to impose a sentence that the judge originally could have.
It seems like that is a rewriting of what the legislature's done. The legislature could have done that, but they chose not to do it. They could have allowed the trial court to make a finding that the offender does not present a danger to the public and allow a reduction to a non-state prison sanction based on that finding. But that's not what they did, is it?
They did not write it in that specific way, but again,
They
if you...
did the exact opposite, it seems to
No,
me.
But the reasonable interpretation, and it is an interpretation, and, this court, I'm sure, is well aware that if you can uphold the constitutionality of a statute as long as it doesn't conflict with the federal or state constitutions or the legislative
But
intent.
we have to uphold the constitutionality of the statute that the legislature actually wrote.
Correct, absolutely, yes, as long as it doesn't conflict with the legislative intent. And the proper reading of this statute, as the state's position, is that you have to consider subsection 3E, which allows for the statutory maximum of up to 5 years, and then you get to point B, which would be subsection 10.
When was this statute, it was subsection 10, when was that enacted?
That was enacted in 2009.
So, okay, so we go back to this issue, which is the legislature, you're saying the legislature intended a top sentence, but that the court had to make written findings.
They intended the statutory maximum always to be 5 years. That never changed.
It just,
Correct.
again, and I guess we go back to this, that it looks like the presumptive sentence is non-state if they're scored at below those numbers, and then there is the additional step to increase the sentence. And I don't know, again, I guess maybe I'm just echoing what some of my colleagues are saying. I don't know how, the legislature could rewrite it to do that, but it doesn't appear that that's what they did, especially if the policy was to encourage non-state sanctions to try to shift for these low-level crimes, shift the responsibility to the counties for jail as opposed to correctional facilities.
Correct, but one of the other policies also was to provide judges the opportunity to take public danger, which is a traditional factor that judges consider, and take that into consideration in determining if a particular defendant is not appropriate for a non-state prison sanction.
Well, I guess, in this case, and maybe it's different when it's assault, but I don't know how somebody being a serial petty thief, that's any crime, I guess you could say, is a danger because it's a crime, but as far as a danger to the people, it seems to me that section contemplates something else about dangerousness, which would be harm beyond harm to a store for stealing things. And so maybe this case, maybe it would have been better if this was an assault case, but these petty theft cases seem like you would have to really find some additional evidence in order to enhance the sentence.
Well, the way the statute is written, the legislature clearly wrote it as, quote, could present a danger to the public. They didn't put limitations on the definition of danger. So that indicates that the legislature contemplated that judges could consider various actions or factors in determining danger. But in this specific case, as an example, yes, this defendant was convicted of petty theft with 2 prior convictions. And in the written order that the judge wrote after the filing of the 3800B motion, the judge specifically found that a non-state prison sanction would not deter this defendant from committing another theft. And he looked at specifically the fact that this particular crime in the instant case was committed in October of 2015. She had a prior conviction in February of 2015 for theft, and then she had another conviction the following month for theft again. And here we are again a few months later, and yet another theft. And
it just
the judge
seems
looked
to
at
me,
that.
though, that a jury hearing this and hearing what she was going through, and clearly, she had a father who, again, the question, there were contested issues as well about whether she had a sick father. She's going along. Was she homeless at the time?
That is not clear in the record, Your
Right,
Honor.
but if it's presented to a jury, there's a lot to argue in this case.
Well, we're speculating as to what the background factor was, and as Justice Kennedy noted, we're not sure if there is even a PSI, and I don't believe there was, so we don't know what type of background this individual had.
I guess what I'm saying is about how a judge will look at this versus that there are real issues of fact that a jury could determine and should determine if they're going to be given a state prison sentence when they don't score for a state prison sentence?
Well, I think in this case, obviously, because this defendant is no longer incarcerated, harmless error analysis, which I think is what you're trying to get to, Your Honor, wouldn't really apply. But if you look at harmless error, and let's assume she was still incarcerated, I think a reasonable jury could, in fact, based on the facts that were presented to the court, the criminal history that the court cited, which dated back to 2004, the fact that these thefts occurred in such a short period of time and the defendant did not learn from the 2 prior convictions for theft.
How do we do harm? Isn't it the burden on the state to prove beyond a reasonable doubt?
Correct.
That no reasonable jury would have concluded otherwise?
Correct. And looking back again at the criminal history, the 3 thefts that occurred within this time frame, the fact that this defendant was not deterred and committed yet another theft, we think that a reasonable jury, if they were submitted with this, would conclude that this defendant will not learn from a non-state prison sanction. But Judge, you alluded to, or Justice rather, you alluded to the costs to society. And theft does have a cost to society.
Oh, no, I'm not saying that theft is there's no crime that's a good crime, okay? I just looking at whether a danger is different than, it used to be with the departure sentence, an escalating pattern of criminal activity. There are all sorts of things that could allow for an increased sentence. Danger to me is not the same thing as saying that there is a potential, again, just a person who has a mental illness, who's maybe homeless, and that's not, to me, the kind of danger, and that's why, again, I think this jury might have, I don't think you can say it's harmless if we were to reach that, that's all. Maybe we're just looking at danger differently.
No.
I want to focus back on your earlier statement that the legislature obviously intended the statutory maximum penalty to remain 5 years, and give you an opportunity to address the language in Blakely saying that the statutory maximum for Apprendi purposes is the maximum sentence that a judge may impose solely on the basis of the facts reflected in the jury's verdict or admitted by the defendant. Because it seems pretty clear the way that the statute that we're talking about is drafted, that the maximum sentence that the judge may impose absent a finding of dangerousness is a year in the county jail. Is that correct?
Well, if you look at it that way, Your Honor, it would still be the state's position that there is no constitutional issue because the finding of dangerousness, particularly to how it was made in this case, did not violate the Sixth Amendment. It's a finding that trial judges...
But the jury didn't make a finding of dangerousness.
They did not make that specific finding, but the trial
Was a
court's
finding
finding...
of dangerousness necessary under Florida law in order to have a sentence over a year in the county jail?
If you get to this subsection, after subpoint A, which would be subsection 3.E, if you get to subsection 10, yes, the legislature stipulated that a finding of public danger had to be made in order to
the
sentence.
maximum sentence in this case, absent a finding of dangerousness, was a year in the county jail.
If the defendant qualifies under subsection 10, yes.
Which she did.
Which she did, correct.
Okay. So for Apprendi purposes, why isn't a year the maximum sentence under Blakely? Just reading it.
Correct. Well, 2 points I would make. Number one, as I argued earlier, I think you really do need to consider subsection 3.E, which is the starting point, the statutory maximum. But the other point would be, and I apologize, I can't recall which specific U.S. Supreme Court case discussed this, but there was a discussion that the statutory maximum that they looked at, the relevant statutory maximum, really had more to do with whether the court was considering other factors that enhanced how that crime was committed and therefore enhanced the defendant's potential exposure to crime. Essentially where the statute reclassified the offense from, for example, a second-degree felony in Blakely and turned it into a first-degree felony. And it was a sentence that the defendant could not have contemplated because he wasn't charged with a second-degree felony. It doesn't quite work the same way in this case. This defendant always knew that a conviction for a third-degree felony subjected her to a statutory maximum of 3 years. And it was only by qualifying...
if she had pled to this, wouldn't she know that absent a finding of dangerousness, the max she could face was a year in the county jail?
Even knowing that, I'm not sure, I don't think there's any evidence in the record that that defendant, this particular defendant, believed that that was the statutory maximum versus the maximum if she qualified under the statute.
But the Apprendi analysis doesn't depend on the subjective appraisal
Correct.
of the situation by a particular defendant, does it?
No, it does not. But in this case, as we said, we really need to look at the entire structure and read both subsections together before. But the bottom line is, if you just look at subsection 10, it's not providing the big picture. Subsection 10 is a part of the application of the original statute.
When did the defendant know, or when did the court know that this defendant score was 22 points or lower? Is that done before the trial or at the conclusion of the trial?
I believe, if I recall correctly, it was at the sentencing hearing where the score sheet was done, and I believe there had to be some corrections made to the score sheet, and that was where they realized the sentencing points are 16.4.
So at the time of trial, this was a third-degree felony?
Correct.
And
Correct.
only when we get to the point where there was sentencing and a score sheet was actually done and the number of points applicable to this particular defendant was determined, do we get to subsection 10?
Correct, and if I know I'm running out of time, if I may quickly add, Your Honor, and that goes to the whole, the idea of notice to a defendant. This defendant had noticed that the maximum was 3 years, so there is no due process implications under the 14th Amendment of any type of notice issue for this particular case. But again, to summarize, because this is not an enhancement statute, the statute, if you look at both subsections, works to mitigate a defendant's exposure, or potential exposure for a third-degree felony. We would ask that this court finds it does not violate Apprendi or Blakely and affirm the 5th DCA. Thank you.
Just a few points. I think the argument that 5 years prison is on the table for Ms. Brown, the best way to show that it wasn't is that if the trial judge here imposed a 3-year prison sentence without making the additional findings, he'd be reversed. So it wasn't on the table. That wasn't an available option. Also, the statute doesn't reference anything with 3E.
The same principle, although Apprendi would not be involved, would apply if the judge wanted to go beneath the recommended guideline sentence, wouldn't he? The judge would have to make factual findings to justify going beneath what the guidelines call for.
Correct, and that would not be obviously a violation.
It would not be a violation of Apprendi, but it's the same process takes place.
Correct.
The judge has to write written, in fact, in most sentencing orders.
Correct.
There's
yes.
a number of factors that justifies a court going beneath the guidelines, and nowadays all the judge has to do is check 2 or 3 of those.
Correct.
And
yes.
those are the written findings, but there has to be something in writing to justify a judge going beneath the guidelines.
Correct.
Okay. Same process.
Yes, and that's obviously the 6th Amendment doesn't, prohibit mitigated sentences.
So here, once the defendant was convicted, the sentencing hearing is convened, the score sheet developed, we see that the defendant is less than the 22 points. And so what, in practical terms, should have happened at that point? What are you saying the judge should have done at that point? Assuming the judge was not going to give her the non-state prison sanction
right.
called for under 775, what should have happened at that point?
Well, even before that, the prosecutor could have used a special interrogatory or a special verdict form to have the jury determine whether the person was a danger to the public or if they wanted to present additional
I
information.
assume the prosecutor would have then had some notion that this person was going to score
right.
22 points or less.
Right.
Okay.
And if they didn't do that, which they obviously didn't here, then the judge would have to have either the same jury make that determination, or if if it was a plea, impanel a jury specifically to make the finding.
Well, hopefully with a plea, it's contemplated. I mean, if
Right.
the state is going
Right.
to seek above what the jury would have found. And I
Correct.
mean, I think going back to what Justice Lawson asked your opponent, I mean, I don't think there's anything better than the statement in Blakely versus Washington that, on page 503, that the sentence is the one that can be imposed based on what the jury finds. And there's no question here that was what was actually, I mean, this is a jury issue. What was, I don't know if our record has it, what was the evidence that she stole? I mean, what was the defense?
There were very few witnesses. I think it was just the loss prevention officer, maybe a video, but it was very,
And what was her
very short.
defense? What did she present as a defense?
There wasn't much. It was on video, so, it was a pretty short trial.
And the jury, so the finding of the jury was she stole these items?
Correct.
No issue about what she had done before?
Correct.
Nothing?
Right.
Did she take the stand?
She did not, to my knowledge.
And so she was convicted of a third-degree felony.
Correct.
And so that jury verdict alone would have subjected her to the 5 years. Just that verdict, we haven't gotten to a score sheet yet. That
Ignoring the
verdict alone
statute, yes.
would have
Yes.
subjected her to the 5 years. And so, something else had to be done in order to have subsection 10 come into play, correct?
Correct.
Okay. Which was the development of the score sheet.
Correct.
And so, I'm just trying to figure out here, if Blakely and Prendy and all of those talk about the only sentence that you could have been imposed based solely on the jury verdict, in this case, would have been the 5 years.
Prison?
The 5-year, that's the maximum sentence for the third-degree felony, right? And without anything more, that's the sentence that could have been imposed.
You're saying prison, though?
Yeah,
5
I
years,
think 5
because
years
5
is
years
prison, it's
duration
not-
is,
but
yes.
5 years prison, yes.
5 years duration is on the table, but prison is not. That requires the additional finding under the statute. So the trial court has.
Wait a minute, so, I'm sorry. If you're convicted of a third-degree felony, 5 years prison is not on the table?
Not for Ms. Brown.
No, I'm talking about a third-degree felony. The maximum sentence is 5 years.
For a third-degree felony, yes.
And that's what she was convicted of, a third-degree felony.
Correct.
Okay.
Adherence to the guidelines, recommended sentences is mandatory unless the judge can find a reason not to exceed or go beneath. Am I correct?
Correct, yeah, the first sentence says must.
So despite the fact that the statute calls for a 5-year sentence, the judge cannot give a 5-year sentence unless there's a reason to exceed the recommended sentence by the guidelines.
Correct.
And once there is a reason to exceed the guidelines, then the judge can sentence all the way up to 5 if he wants to.
That's correct.
So by statute, the sentence to be imposed is already scheduled, set.
Right, yes. And I would just like to note too, I know the state's in a difficult position here, but, trying to defend the decision of the Fifth District Court of Appeal, but the Attorney General in the First District Court of Appeal did concede that Apprendi and Blakely applied to the same facts of this case. I know, again, it's a difficult position to defend, but we think it's pretty clear here that Apprendi and Blakely applied, and we would just ask that you reverse the decision of the Fifth. If there's no further questions? Thank you.
All right, we thank you both for your arguments. The court will now stand in recess for about 10 minutes.
All rise.